Hello and welcome to EPR with your favorite environmental enthusiasts, Nick and Laura. On today's episode, Laura and I talk about waters of the United States. We have Ted Boling back to talk about NEPA updates, teaching, and CEQ. And finally, the Grand Staircase Escalante National Monument, which we talked about with Ted, was established in 1996 and covers an area of more than 2,900 square miles. There are 3 regions of the monument, including the Grand Staircase, which is a series of 5 steps rising about 5,500 feet. And each step basically has a different expanse, landscape, and biome, ranging from barren desert to evergreen forest. Then there's the Copperwitz Plateau, which rises above the surrounding land in the center of the monument and contains prehistoric artifacts, including dinosaurs. Like, what? Okay, I'm in. And finally, in the northeast, there's the Escalante River, which is cut into the sandstone over many millennia and has a lot of really neat canyons and hikes that make things a little challenging for hikers, but very, very fun, very, very cool. So yeah, there you go. That's what I got for you. Laura's unimpressed, I think.
You didn't convince me. You sounded questionable.
To go? I mean, it's also, okay, I'll put it this way. South Utah has some of the most beautiful and unique landscape in the country. Absolutely worth going to. Super, super cool. And like I say, if you love hiking, you've got to do it. Like it's vertically quite stunning. So, and did I mention dinosaurs earlier? Did you not hear me say?
All right. No,
you can find your own fossils. That's how cool it is. That's it. They keep finding them. Like since 2000, they've found like dozens of new species. I'm just saying, I might be inflating the numbers to prove my point. But the point is, you should go. It's great. It's a wonderful part of the country. It's very unique. Arches is another really cool area that everyone goes to, that red desert type stone. Very neat. So there you go. Just go do it. Do it for Ted. Do it for Ted. Not
keep talking. I'm going to try to reach out to the Utah Tourist Board and see if they'll sponsor us.
Perfect. Hit that music.
NAEP will be hosting the Advanced NEPA training virtually on August 23rd from 8 a.m. to 4:30 p.m. Eastern Time. This workshop will benefit those professionals who work in related natural resource disciplines, who work with federal land management or real estate transactions, federal agency projects or permitting, and transportation or other infrastructure projects with a NEPA review component. Check it out at www.naep.org.
Today's episode is sponsored by Perkins Coie. Perkins Coie is a leading international law firm that is known for providing high-value, strategic solutions and extraordinary client service on matters vital to our clients' success. With more than 1,200 lawyers and offices across the United States and Asia, Perkins Coie provides a full array of legal advice including on the environment, energy, and natural resource issues. This year, Chambers USA named Perkins Coie the Environmental Law Firm of the Year, as well as ranking the practice Brand 1, the highest possible ranking. Please check them out at www.perkinscoie.com. That's PerkinsCoie.com. All right, let's get to our segment.
You know, I never got to a level in my career. I was working boots on the ground stuff, so I was not doing permitting and NEPA things. And I will keep saying, in Florida, we don't talk NEPA. That's not a word that we throw around, or acronym. And so, like, there's some of our listeners who just are like, NEPA, what's all this stuff? Or, you know, that's politics. It crosses the line.
Right.
It's that, but it's still very interesting. And I only know that now after getting a chance to talk to him and Fred and listening, like, oh, these are cool. This is interesting stuff. It doesn't have to just be about the decision makers.
Mm-hmm. I mean, you can even talk about it from like Sackett, right? Is a really good example of like, okay, why should I give it I almost cursed. Why should I give a crap about this, right? And so the Waters of the U.S. definition really defines a lot of how we build things, right? Where we build them. What are the requirements to build? And so you think about like a lake that has houses on it, right? Like, you know, not a big deal. You think, oh yeah, there's lakes here. But every time you do that, you add boats, and boats add oil, and there's all kinds of impacts to the water. So the water is, you know, becomes undrinkable in some cases, or, you know, there's always these things that kind of snowball from a decision, right? So if you build a dam or you remove a wetland so that you can build something closer to the water, all that stuff adds up over time. And eventually, when it rains, everything floods. Houston is a good example of that. So the decision from Sackett is streamlining that, they basically said, there's no such thing as you can build on a wetland as long as it's not connected, and you don't have to prove that it isn't, which is where we were before, right? So then in some ways that means that some states are going to say, I can build anything, anywhere, no matter what the consequences. Should they do that? Absolutely not. They definitely shouldn't, because it's not a smart idea. Does it mean they will? Maybe. But other states will take a different approach. And it's actually written in there too, that states can do things the way that they want. So some states are going to be like, no, this is really bad. Like, we need wetlands because it keeps everything else from flooding. So, it's going to be, it's like streamlining it from a federal perspective, but from each state is still going to take it their own way. So you have to learn all of this.
From a real and practical perspective too, like in Hillsborough County, the regulations are passed down to the state, but then the state are passed down to the county. So while I was working at APC, there was a huge issue with, they were talking about, like, EPC regulates, at least they did at the time, wetlands that are less than a half acre or something like that. And again, going back to my poor memory, I don't remember the exact details. So no one fault me if I get this wrong, but small wetlands, EPC is able to permit for and to protect. Whereas if it's just at the state level, no one cares about. And so that is a whole set of people's jobs. It's a whole set of, and Florida is made up of tiny little bits of wetlands. So if you start chipping away at, 1/4 acre wetland times 10 is 40 acres, right? Is that right math? I don't know.
I don't think so.
Don't put that in the bloopers. Okay, Nick, how much would it be?
So if it's 1/4 of an acre and then times, so it's maybe 2.5 acres.
Okay. So multiply that by how many to get 40?
Oh, a lot more than that.
See, you don't know either.
I don't want to do the math. I don't. No, but
but anyway, it adds up, right? So, and it's permanent. It's not like you're going to like, oh, we messed that up. Let's take down this house and put the wetland back. So I think that's, to me, is like the scariest thing, is like, you can't go back. Like all these dams that we're trying to undo that were put up and are causing all this problems this decades later, like you can't go back and fix it.
It's funny. Florida is a fantastic example of that, because they basically canaled all the water away from the Everglades to the coast. And they did that because they wanted fresh water in Miami, basically. That's what they wanted. And then decades later, they realized, oh God, every time it rains in, Central Florida, all of that water now, all the crap and the muck and the gunk goes to Miami. And they're like, we got to fix that flow regime because it's kind of, it's destroying the Everglades. It's changed the way they do. So what are they doing? They're building canals again. And this time to put the water back where it was originally going, which is just a really funny, amusing, quirky thing, right? It's like if they hadn't done it in the first place, there wouldn't be an issue. But their solution is the same thing that they did that was the problem. So it's a very funny system.
Right, which ties into things like mosquito levels. And, it's just, there are repercussions for these things. And so anyway, why is this important to anybody who is environmental? And even if you're not doing something directly tied to water, because it's all connected.
Sure. I mean, mosquitoes is a great point, because it's like, if you have, mosquitoes bring disease, right? So even the policy impacting people's health, it just stuff that doesn't, like Ted said, words don't do, can't do everything. They can't. It's impossible.
Especially not our words. So let's wrap up this segment, and no one hold it against us that we're talking in generalist terms here. And let's get to Ted, who knows everything in the world. That's just my opinion.
He is a brilliant mind. Hello and welcome back to EPR. Today we have Ted Boling. He is a partner at Perkins Coie LLP and was Associate Director for NEPA at the Council on Environmental Quality, and is back on the show for a third time. Welcome back, Ted.
It's great to be back. Thank you so much for having me.
Of course. And, we were talking before the show, there is so much that we can cover when it comes to policy. We're going to get to a lot of that as much as we can, as long as we have you. But I wanted to start actually talking about you and Michael Drummond did an excellent job teaching NAEP's Advanced NEPA course. Is teaching something you enjoy because you're good at it?
Oh, I just love it. And particularly when you're tag team teaching with someone with whom you've got a great natural rapport is just fun. So I'm actually, I'm going to be teaching a course at GW Law School this fall with Brett Grosko at DOJ on wildlife and law and ecosystems. And, it'll be the full Endangered Species Act, Marine Mammal Protection Act, all that stuff. And it's just going to be great. So I'm really looking forward to that.
It's really awesome. Is that something that you kind of learned through your career, or did you always have that itch to teach and mentor folks?
Well, for many years when I arrived at CEQ in summer of 2000, we had an ongoing relationship with Duke, the Nicholas School of the Environment, where we had a really outstanding NEPA course. It ran until I left CEQ the first time to go to the Department of the Interior, and I still participated in that. But I really enjoyed that series of courses, and I lament that it kind of came to a natural end with transitions in leadership at the CEQ and Nicholas School, and we never really quite replaced it. The NAEP sessions are good for 1 week out of the year, and plus our sort of rotating advanced NEPA course is pretty good virtual attempt at that. But nothing quite builds the community like having everyone in the room like that.
100%. I wish it was still around too. It's in my backyard. So, I mean, yeah. Anyway, so one of the things that you talked about in the training that's also become, more prevalent in the news is talking about people confusing NEPA and permitting and not understanding that they're two different things. Can you help maybe expand on that? Talk through, why do we have this challenge where everybody thinks, well, we did the NEPA, we're good. We don't have to, we did the permit, but there's also a NEPA component to everything.
Well, I think part of the reason is because NEPA is the most public side of permitting, the broader challenge of all the authorizations. I think it's the Title 41 of the FAST Act, that the permitting council authorities do a good job of sort of separating out. You've got covered projects. You have to be in NEPA to be part of the dashboard, but that's just sort of the organizing framework for all the complexities, all of the authorizations and of myriad statutes involved in setting up infrastructure projects. And I'm particularly focused on infrastructure as the example. But at some point, people focused on NEPA because it is a very clear set of timelines there, as though that tracking of timelines was the linchpin. No, it's just a good indicator of the overall process. It's an excellent means of organizing the process. In fact, agencies have found, as the Department of Homeland Security did, when you wipe away with NEPA, you still need that kind of process. And they ended up sort of doing a form of NEPA where NEPA didn't apply. So it's just the logic of it prevails. But the larger issue of permitting reform is going to have to tackle, the larger issues of agency resources and coordination and bringing together all the various authorities, and at not just the federal level, but federal, state, local, tribal, whatnot.
Yeah, 100%.
Awesome. Thank you for expanding on that. Let's take a sidestep for a second, because we always want to touch on careers on the podcast. So looking at the career path for attorneys, is there any typical career arc for them, or do attorneys jump into it just like every other career path in different sort of ways?
Well, it's very difficult to come out of law school and do exactly what you want to do. And so, that first job, I'm a very, rare bird in that regard. And when I got into the Attorney General's Honor Program, I immediately went right to the Environment and Natural Resources Division. I've been very lucky to do pretty much every thing I wanted to do ever since then. A lot of lawyers, they'll go clerk for a judge. They'll get experience that way, working your way around. My Brett Grosko is a paralegal at Justice Department, and then went off to law school. And then he worked for NOAA, and then he's at Justice Department. There are many different paths. I'm a big proponent of public service and working at various levels of government, because I do think it's part of the operating system for the government is to be a lawyer and to know the law. And I think lawyers play an especially important role there.
Yeah. And a discussion that is had in a lot of different environmental careers is, do I choose public versus private for where I'd like to spend my 40 to 60 plus hours a week, depending on what you're doing? And do you find in the attorney world that that's also a valid question to be asking yourself?
Yeah. And I'm really enjoying after the long federal career, being, doing more or less the same thing from a very different angle, and that being in the private sector. Although I work with a lot of, state agencies, clients, and then also clients in the nonprofit sphere who are involved in, public policy issues. So I've managed to have a good mix of it all.
Yeah. Is there one you kind of prefer over the other for yourself after doing both?
No, I'm an omnivore. I enjoy it all. So.
Nice.
That's good. Yeah. I was like, say the one you're doing now. Oh, I love it. And like I say, I want to make sure we find time to ask you some fun stuff at the end here too. But like I say, there's a lot going on in the environmental realm. I actually was talking with a group of folks from the Army and talking to them about it's a wild time to be in policy right now. And so even when I'm telling them today, I'm like, you guys need to have me back because it's going to change. But let's start with the debt ceiling update to NEPA. And the first question I have is, were we expecting this to happen? Because it changed the regulations to NEPA for like the first time. And when Speaker McCarthy appointed Garrett Graves to be his lead negotiator on the debt ceiling, you kind of knew that, this has been on his radar screen with Builder Act, and Garrett Graves is going to do something in this arena. And I think, we were all sort of trading rumors and such, and it was really more a question of scope and scale rather than whether. There was some discussion after the fact that, when they did a little study for NERC, the National Electric Reliability Council, to study transmission. For me, transmission and the electrification of the U.S. economy is the heart of the issue. We don't need a little study provision. But Garrett Graves said, well, we didn't really, have basically the wherewithal to deal with transmission in the context of debt ceiling. So they chose to negotiate basically on what he had focused mostly on, which was his amendments to NEPA proposed in the Builder Act. And that became the focal point. There's still a lot to be done with regard to improving our approach to the transmission and other aspects of infrastructure development. I'm expecting there will be a broader permitting reform effort, and the amendments to NEPA are sort of a down payment on that. Gotcha. Yeah. And one of the more interesting ones I noticed right away was the inclusion of project sponsors, where an agency could get a third party to do their NEPA with their oversight. And I know that's happened in New York to some effect, which they, I think the kind of the baseline for why it's put in there.
Well, actually, it was in the 2020 NEPA regulations. It's got a long genesis to it. I mean, for the longest time, project sponsors could do an environmental assessment. Anyone could do an environmental assessment, but we have a special rule under the 1978 regulations for environmental impact statements that you'd have to have this sort of arm's length relationship where, the project sponsor could fund the NEPA analysis, but it's basically under the oversight of the agency, which created at times opportunities for confusion or inefficiency, project sponsors feeling like they're just throwing money to a contractor with which they did not have any good, strong relationship. And that's important for purposes of bounding the analysis, understanding the limits of technical and economic feasibility, what's a reasonable range of alternatives and mitigation measures, those sorts of things. So in the 2020 amendments, there's a robust debate as to whether to keep that arm's length relationship or not. And the administration decided to just open it up and create a practice where EAs and EISs, they're all the same in that respect, but emphasize agency oversight of the process, agency capacity to understand, distinguish between, like a robust environmental analysis that considers alternatives, is responsive to public input versus one that engages in some greenwashing of, avoidance of discussion of hard issues. And that remains the challenge. And certainly CEQ is going to be taking that on as part of their phase 2 rulemaking.
Yeah, which leads me to one of my questions here too. There's a lot that's in here that it was, but is it going to delay the phase 2 rules? Are we going to, because phase 2 is going to have to address some of what's in here, I think.
Well, by the time this podcast airs, the phase 2 rule might actually be out. And it was at OMB, has been at OMB for interagency review since I think January. I understand in response to the debt ceiling, or rather the Fiscal Responsibility Act, amendments. They took it back and did some redrafting. I'm expecting it'll go soon, as Brenda Mallory indicated to Chairman Carper in a hearing just before the debt ceiling that it would be coming out soon. So given that many of the amendments to NEPA are really more sort of codification of what was in the 2020 regulations, which is based on, the history of case law and such, they might not, I don't know what was in their draft, but they might not have had too much work to do in updating it.
Gotcha. Yeah, understood. So you also mentioned, and you were quoted in the NE article talking about the changes to what constitutes a major federal action.
Yeah.
And, saying that major actions only apply when an agency has substantial federal control and responsibility. And that phrase begs a follow-up. So what do you mean by that?
Well, I think it's going to be agency-specific, fact-specific, and authority-specific. And what are the limits of their control, their responsibility? Where does NEPA occur within their decision-making processes? I think CEQ can do a fair amount in its phase 2 rulemaking to help define those terms. I mean, it's interesting how Ledge Council broke up the definition of major federal action that was in the 2020 regulations at 1508.1Q, if memory serves. I mean, they sort of created some tension in there and some interesting word changes. But what is it's minimal federal involvement, minimal federal funding. Generally, in the funding stream, there are cases out there where they 5, 6, maybe even up to 10% federal funding was in those particular circumstances not sufficient to quote federalize a project or a proposal. Also, whether it's the federalist fundings for like a study or if it's actually for the implementation. But in some cases, you can imagine where federal funding would be the linchpin. It would not happen but for that last increment of federal funding. So it's going to be up to CEQ to set the ground rules for that, and then very importantly, agencies to update their own implementing NEPA procedures, tailoring the CEQ rules to their particular authorities.
Yeah. I mean, like I said, it's buckle up, right? Yeah. Lord,
I get anxiety just listening to you guys.
It's exciting.
It really is. It totally is.
It's more about the retention of the changes and all of the different parts. So I always consider myself sort of voice of the little people on this show. Those who are listening who have no idea what you guys are talking about, but want to, right? Because there's a big contingent of our listeners who are not just starting their careers or haven't started at all. I know, I would not have known who CEQ was or what that even stands for. So let's step back a second. What is CEQ's role and what comes first? Because it seems like this never ending, this came out of DC or the White House but the agencies are doing this, and who are the people in the moving parts?
Okay. So to explain the dramatis personae there, sorry, the players in the action here. So the Council on Environmental Quality, CEQ, is a little agency in the executive office of the president, which includes Office of Management and Budget, and all those, Office of Science and Technology Policy, all those sort of agencies that serve the president and his immediate advisors. CEQ was created in Title II of NEPA. And so I encourage everyone to read the statute, especially now that it's been amended. It's, Section 101. It was minimally amended, and that's sort of the mandate. That's the national environmental policy to achieve greater productive harmony between us and our environment, and using federal authorities to do that. And Section 102 creates the mechanism that implements that. That's the environmental review processes. And then Title II, it creates CEQ to oversee all that. And there are other authorities that flow from that, but that's sort of the basic framework. And CEQ, it has oversight authority over all the federal agencies that do the NEPA work. They do the application of the environmental policy to their particular programs. How's
that?
Yeah.
Thank you. And then follow up to that. How do you remember all this stuff? So as a person who inherited terrible memory, and I'm always just in awe of people who can just recite policy numbers and, revisions and, read this version of that. I'm like, I get numbers mixed up back and forth. So what's your secret sauce? And because I think anyone trying to get into an attorney role or something that even is just like high level in policy, probably need to have some level of being able to remember stuff like this, especially if you want to teach it or talk off the cuff. Any secret sauce that you use to be able to remember this, or it's just years of doing it?
Yeah, it's just kind of an occupational hazard. And I having lived and breathed the regulations backwards and forwards in doing the redraft, and even still, I mean, I actually, when I first got to DOJ and I was involved with actually responding to, inquiries from the Council on Environmental Quality back then. And I actually just sat down with their regulations. I was particularly at that point, I was involved in an ecosystem study project, if you will. It was around the time of the Northwest Forest Plan. And I was just interested in how does ecosystem show up in the CEQ regs? And I just ran through them all, front to back, just, really studied it in that way. And I've always kind of, you start with the statute and then you read the regulations. I think everyone should have that basic level of understanding if they're going to practice in this area, and then build out from that. I mean, at times I can remember sites for cases when they're particularly important, but that's sort of like working knowledge, and that's a good day, or I can come up with a citation.
So you didn't have like the stuff written on the back of your hand or something for a while.
I do kind of have the 17 Supreme Court cases that, it dealt with NEPA in the back of my mind, and a few others that are just kind of, particularly handy.
That's very cool. So, okay, we're talking about some of these changes coming up. We got phase 2 coming up. There's page limits that were also in the debt ceiling update. Is there anything else from there?
Well, page limits aren't new. Page limits are in the 1978 regulations. People page limits. They're like, come on, It's like, okay, you write for clarity and meaning. You give the decision maker a document that person can read in an afternoon, or a reasonable amount of time that gives them what you need to know about what's significant here. What's the process? Who cares about what that's, and what are the alternatives? What's the mitigation? What are we proposing? And what's your range of decision making? And, the bulk of it goes to appendices. And if you've got a decision maker like, some that I've worked with who they really want to dig into a particular issue. I mean, Sally Jewell, Secretary of the Interior, springs to mind. And on the Eisenbeck Road case, she was like, well, wait a second, where did it say that? We go down, really construct a record of decision based on the environmental document. Then you have that available. But really, we don't want to be saddling decision makers or the public with, reading thousands of pages. I once looked, I think it was the Desert Renewable Energy Conservation Plan. I figured out that at my reading speed, which is about average, it would take me 21 8-hour days to read the entire draft EIS.
Wow.
I don't have that time.
Yeah, nobody has that time. Oh my gosh. Yeah, but it's funny because it keeps popping up. We keep adding it into everything. I mean,
it is a challenge. I mean, it's like the old adage, sometimes attributed to Lincoln. I would have written you a shorter letter if I'd had more time. And it is a good writing, writing for meaning and making those judgments about what we're not going to put in the environmental document. Those are tough things, especially for lawyers who are like, just throw it in, throw everything in.
Cover your bases. Yeah. And then it's an EA that's, hurt you if you threw it at somebody. Yeah.
It's in there. It's in the appendix. It's okay.
Yeah. Right. Well, is there anything else from those changes that was interesting to you that popped up in?
Well, yeah, there's some things in there that frankly worry me. In particular, the idea that an applicant could run to court to try to enforce a timeline for the NEPA document. I just don't know how that's going to work. I mean, it's sort of a threat that hangs over the NEPA process. And frankly, the way they codified aspects of the regulations, an important part of the 2020 regulations ethic was we're going to have, senior level people. We're going to have, agency officials not treating NEPA as sort of a disconnected part of their process, but actually important, something that they need to pay attention to, something that they need to resource. And so that's why we had timelines that were sort of indicative. An EIS ought to be about 2 years. unless a senior agency official gives you more time in a written schedule. We want to have that kind of buy-in and supervision to say, okay, this is big and important. We're going to take more time with it, but not, an infinite amount of time. It's just, here's how we're going to structure the process, and we're going to do oversight. That kind of was left on the cutting room floor. And it's a fairly absolute, 2 years for EIS, 1 year for an EA, ambiguity about the starting point. I mean, there's some drafting issues in there. So that kind of concerns me. And I think we'll see how CEQ addresses that.
Okay. Yeah. And then what is your advice then for agencies as they're trying to implement the new regs?
I've been saying for several years now that, they should just focus on good NEPA practice. I mean, the fundamentals have not changed. If anything, they've become more fundamental. I mean, some of the better aspects of the amendments are just codification of, reasonable foreseeability of just a range of alternatives being based on, what's technically and economically feasible. I mean, it's the purpose of need. I mean, these are kind of fundamental ideas that are now written in the statute, as well as also, the usual hierarchy of, EAs, EISs. I think the treatment of categorical exclusions deserves some explanation. I think that the main message for agencies is don't go looking for radical changes here. And that inevitably there will be people who do that. But just, good NEPA practice, particularly focused on just, what is the nature of the agency decision? What's the environmental effect of the agency decision? That's the starting point.
Yeah.
That's great advice. I have a follow-up question on that one. Are there any tools or tips or tricks for the agencies that you know of that will help them? I don't even know what I'm talking about, but something that if I am an agency that is not familiar with this or has new staff or something, is there training? Is there some resource or website or someplace I can go to figure out, how do I do this better?
I think the first tool is good communication with the experts. We have a NEPA contact, sort of the leaders in the brain trust, if you will, within the federal government, and particularly CEQ, and just having good communication with that network of NEPA practitioners, I think is important. Every agency has those people, or at least they should, and having a good network of NEPA contacts is part of the responsibility of the director for NEPA, who's now called at CEQ, maintaining. I'm imagining that there's a robust dialogue going on within the agencies, because I used to be a part of all that. And I missed that, but we have a sort of outside version of that through NAEP.
Yeah. Perfect.
Fantastic.
Yeah. And so, I mean, like I say, there's NEPA. There's also been a couple of other, wild things come up. I think the Sackett ruling for waters of the U.S. is also very, very interesting. And it's, we got a ruling with 4 opinions, which I thought was kind of wild. And I don't know, we'll just start broadly. This is a big change, I would say. I think it streamlines things, is one way to put it. But what are your main takeaways from the ruling?
First of all, I've been hearing people say, let's not do to NEPA what has happened to waters of the United States, where it's sort of like pendulum swing. That's
my goodness. Yeah.
You kind of wish that it would just settle down. I mean, I remember back in 1990, 92 or so, and it's rulemaking, and people were talking about, well, the line is going uphill and it's reaching farther, and the issues of adjacency. And, I think ultimately I'm a creature of the administrative state. I think that, the Army Corps and EPA will eventually settle down on a workable set of rules here that gets deference, because ultimately we can't have the Supreme Court rewriting the rules every 5-10 years, or however long, for the Supreme Court to once again say, we need to step in and clarify things again. And then having a good system of oversight, so that you have a coherent framework that has some regional differences, because tremendous diversity in the United States. In the West, we have aridity and issues of hydraulic connection that you don't have in other parts of the country. I have faith that, APA and the Army Corps of Engineers will, in response to SACIT, come out with a good, coherent framework that we can all live with, and maybe things will settle down.
Gotcha. Yeah.
I love that positive outlook.
Yeah. Yeah. Because it has been really wild. I mean, I would say even from like 2015 to now, it's just like you said, it's been a pendulum. It is just, back and forth. It's almost like we're playing tennis with waters. What even is a water,
Yeah. And it's the whole nexus question. And it almost shows you where words just can't do it.
Exactly.
They need to have an engineering test that works from the standpoint of hydrology rather than English.
Right. Yeah, exactly.
Yeah. Well, Nick pointed out that there are 4 different opinions on this. My question, again, from a layperson is that how is the Supreme Court, or do each of them have their own team of people who are helping them make these decisions? Like, what makes them qualified to even determine this information?
Well, Justice Kagan noted on another case, they're like, well, you're not sitting before like 9 experts on the internet here. They all have to have a good deal of sort of humility, but then also, reliance on just good briefing. And that's where, particularly the Solicitor General's office, does an extraordinary job of just checking everything, making sure that it's not just a really tight case, but it's well sourced, it's well defined. Every brief produced by the Solicitor General's office is an exquisite work of lawyering and just good coordination.
Yeah, because from the outside looking in, it just looks like here's my opinion. It's hard to see that they're actually fact-based, but with different pieces of information, possibly.
That, and it's also part of a huge workload. I mean, it's, here we are. I mean, right now we're waiting for a Supreme Court decision in the Navajo case involving tribal, treaty rights on the Colorado River. And it's one of many. At the end of June, they're just, hanging fire. We have this dam break of opinions coming. It's a mind-bending amount of work.
Yeah.
If you've ever read, there's a great book about the Burger Court called The Brethren, one of Bob Woodward's first books, and it's an outstanding window into what life is like up there. I understand.
Oh, cool. That sounds
very
interesting.
Cool. Yeah.
Stands the test of time, even if the justices have all changed.
Right.
Right.
All right. Well, it's time on our show, we do a segment called Field Notes. It's the part where we talk to our guests about their memorable moments in the field. And you've done this before. If you're listening and you have fun, scary, interesting moments in the field and want to share with us, use the hashtag Field Notes. So Ted, it doesn't have to necessarily be boots on the ground in the field work, but could be on a stage in front of people. Some of our field presentations have been, or field notes and funny stories have been. Anything from your past experiences or anything recent you want to share has been interesting?
Well, I'm wearing my Grand Staircase Escalante National Monument T-shirt for a reason.
Nice.
It's one of my happy places. I got involved in monument designation when the Lois Schiffer, the Assistant Attorney General for the Environment Division, said, I've got a super secret squirrel project. I need you to go over to, meet with John Leshy, the Solicitor of Interior, and work on this. And we basically, a small team, worked for a month or so cooking up the first monument proclamation since the Carter administration used the Antiquities Act
wow.
for Alaska conservation. It's related to the enactment of ANILCA. And so, I became fascinated with that part of the world because what you do with a monument proclamation is you learn as much as you can about objects of historic or scientific interest that are the basis for the designation of the monument. And the area is fascinating geology, fascinating ecosystem. And then finally, it was designated by President Clinton. Of course, it went through litigation. I was involved in that. Trump trifurcated it, and then President Biden put it all back together. And I finally was able to go visit there. I went to Calf Creek Falls on my birthday a few years ago. And it's just, I've got the T-shirt from that trip. And it's just
awesome.
I'm looking forward to going back there. My daughter, who's currently in graduate school in the Netherlands, she's my hiking buddy. And we're like, we've got that on our radar. We've got many trips back to Utah left to do, just sort of scratch the surface there. But that's where I want to go. My most recent trip was hiking with my daughter in the Highlands of Scotland.
Wow. Yeah.
That sounds terrible. How long did you endure that madness?
Oh, I was tracing back a little bit of my genetic heritage there. So I'm Kirkdale relative of the Gordon Highlanders. So.
Oh, wow. That's very, very cool.
That's cool. How long was the hike?
Oh, it was good all day up Ben McGuey through, we saw reindeer and it was snow at the end of May and it was just fun.
Heck yeah. Love
It's
that.
the second highest peak in Scotland. We got Ben Nevis is the next one. And I may be butchering the pronunciation. Notes on the way.
Oh my gosh.
That's okay. That's really awesome. We're running out of time. This went by really fast. Is there anything else that you want to touch on or talk about?
What a loaded question.
I mean, it's.
We have 2.5 more hours. Anything else you want to talk about?
No. I do think the permitting reform debate, which is going to continue, particularly with this focus on transmission, is going to be hugely important. And frankly, it could be cast as a national security issue. I mean, frankly, the energy security, the security of the nation is so important for purposes of, conversion of our energy system to offshore wind and, renewable power. And we need transmission to actually bring that to market. And that is a Gordian knot that, people have been after since I remember the Cheney Energy Commission basically identifying in 2001 the same sorts of problems that we're trying to deal with now. And so I'm looking forward to working on that problem and working with the environmental professional community. How do we, marry up our interests of both climate change as well as just, conservation and addressing the location and alternative issues there. I think it's going to be great work. So I'm excited for it.
Yeah, 100%. It's really, really. Yeah. Sorry, I'm getting excited while you're talking. I can't help myself.
That's my objective then.
Yeah. That's really great. I mean, I'll follow up here really quickly too on wind energy. I know that's very important to you now. Is there any new updates there worth mentioning?
Oh, well, yeah. The Bureau of Ocean Energy Management has been leasing off the coast of California last December. They've got work, planning to lease in the Gulf of Mexico, which will be very interesting because there's a lot of, good oil and gas infrastructure there with the capacity to convert to building wind power. I mean, the wind resources aren't as great as they are, say, off of Martha's Vineyard or Humboldt, California, not as strong and steady. But on the other hand, it's a sort of industrial backyard for a lot of the marine industry that's necessary to construct this. So it's an exciting time in that regard.
Very cool.
Awesome.
Right, Laura. Yeah.
All right, you done, Nick? All right, Ted, where can people get in touch with you?
Well, you can find me at Perkins Coie. That's PerkinsCoie. And, Ted Boling at PerkinsCoie.com.
Perfect.
Awesome.
Cool.
Thank you for being here again.
Oh, I should mention, we were just named by Chambers, the law firm rating service, as the environmental law firm of the year for 2023.
Oh, congrats.
Well, congratulations.
That's awesome.
That's awesome. Yeah.
Yeah.
Great.
All right. Thanks.
Thanks, Ted. And that's our show. Thank you, Ted, for joining us today.
And thank you to Perkins Coie for sponsoring the episode. Perkins Coie is a leading international law firm that is known for providing high-value, strategic solutions, and extraordinary client service on matters vital to our clients' success. With more than 1,200 lawyers and offices across the United States and Asia, Perkins Coie provides a full array of legal advice, including on the environment, energy, and natural resource issues. This year, Chambers USA named Perkins Coie the Environmental Law Firm of the Year, as well as ranking the practice Brand 1, the highest possible ranking. Please check them out at www.perkinscoie.com. That's PerkinsCoie.com.
Please be sure to check us out each and every Friday. Don't forget to subscribe, rate, and review. See you, everybody. What was that?